Will there be music? No.
Oh, sir, we have not incorporated music yet. But we do have people coming in. Oh, wow, coming in pretty
Really,
quickly.
really quickly, what's the order between Chief, Dean Leeds, and myself?
I was going to have, if it's okay, having Dean Leeds start us off with kind of a background, and then having Chief Wynn come in with what's going on today on the ground, and then, if you don't mind, kind of where we go from here, you know, what the next step is, what questions are being answered, and that sort of thing.
Perfect. Yep.
Awesome. Wow, we jumped from 19 to 50 in like a second. And so I do want to say we are going to kind of get started and do this deep dive here. We're going to give about 3 minutes for people to kind of trickle in a little bit. I see the numbers are still going up. To let you all know, my name is Nate Todd. I am the Dean of Diversity, Equity, and Inclusion here at TCC. So thank you so much for being a part of this call. But we're going to wait about 3 minutes, and then we're going to jump into the discussion today. Amazing. We do have some amazing speakers today, a part of our panel that's going to really give us some insight on what's going on with this Supreme Court decision, and just some housekeeping rules. If you are on Zoom, if you go up to the the right-hand corner of your screen, it will say speaker view. You might want to click on that. That will just make sure that the person is talking is right there, center point of your screen. And if you have any questions, please put them in the question and answer section down there at the bottom bar of the Zoom link. Or if you want to put them in chat, you can definitely put them in chat too. We are monitoring chat and the question and answers, and we want to be able to answer your questions. So please engage with us there. Just a few more minutes. No, Chief Wynn, we will definitely look into how we can incorporate music. It's always this awkward silence, right? That kind of gets people sometimes. And so we're gonna wait about 30 seconds to a minute, and then we jump into the discussion. All right. Okay. Let's jump into the discussion. Once again, thank you, everyone, for being a part of this event today. We have a pretty large participation with this discussion today, which is very highly important to the people here, not only here in Oklahoma, but our nation, our students that go to TCC. And, you know, today we will be talking about this Supreme Court ruling about the native indigenous lands here in Oklahoma. And we're going to be doing kind of a deep dive into how that actually affects us here in Northeast Oklahoma, and possibly the nation in its entirety. And so we really look forward to this discussion. This is part of the series for celebrating our Indigenous Heritage Month. And so we do have another event planned that we will let you all know about at the end of this great discussion. But really, once again, thank you so much for being a part of this discussion. Let us know if you have any questions by putting them into the question and answer section or in the chat. We would love to answer those questions, and we are going to jump into the discussion. And so what I'm going to do is turn it over to Dr. Mcgirt, who is an assistant professor of history here at Tulsa Community College. Dr. Mcgirt.
Good afternoon. Thank you everyone for joining us today for this important discussion. I'd like to also thank Dean Todd and Carla Morton and everybody over there at Diversity, Equity, and Inclusion. Thank you guys for helping us to make this event possible. I'd like to start off with kind of a brief introduction of our speakers who we are very honored to have with us today. Judge Stacy Leeds is a Dean Emeritus and Professor of Law at the University of Arkansas. She teaches American Indian law and property law and has authored over 30 essays, articles, and book chapters. From 2011 to 2018, Dean Leeds was the 12th Dean of the University of Arkansas School of Law, making her the first Native woman to serve as a law school dean in the United States. And this is not the first that she broke. Judge Leeds was also the first woman to serve as justice on the Cherokee Nation Supreme Court. She currently serves as a district judge on the Muskogee Nation, for the Muskogee Nation as a district judge and appellate judge for the Perry Grand Potawatomi Nation. We are also welcomed and very happy to have Chief Daniel Wind III of the Muskogee Nation Tribal Police Department. He's been with the Muskogee Nation Tribal Police Department for over 15 years. He has degrees in criminal justice, law enforcement administration, and political science from the College of Muskogee Nation, Haskell Indian Nations Universities, and Oklahoma State Universities. We also have Ambassador Jonadev Chaudhuri, who has extensive knowledge of representing tribal nations and tribal citizens on issues related to commercial litigation, gaming, governance, tribal sovereignty, and self-determination. Ambassador Chaudhuri has served as the National Indian Gaming Commission Chairman from 2013-2019. He served as a counselor to the U.S. Department of Interior's Assistant Secretary of Indian Affairs. And throughout his 20-year legal career, he has served as a judge on 5 different tribal nation courts, including as Chief Justice of the Muskogee Creek Nation. So thank you to all of our panelists here this afternoon who have taken their time to be with us and to kind of discuss what's going on with this very important landmark Supreme Court case decision in Mcgirt v. Oklahoma. Now, all those of you who are out there who have a lot of very important and interesting questions that we would love to get to, if you have questions, just type them out in the chat box, and I will be happy to address those and turn them over to our panel. But I thought we'd start today with kind of a background of tribal sovereignty in the United States up through the Mcgirt decision. And I was hoping that Judge Leeds could start us off with this discussion, if she doesn't mind.
You bet. Thank you, Professor Mcgirt, for the panel, and to Dean Todd for hosting us. It's the first time I've had an opportunity to be part of a TCC campus program. So I want to wish you all a happy Native American Heritage Month. And what I am going to launch into is about a 5-minute Indian law over 2 centuries, and get us to the point where we're talking about the case of Mcgirt. So what I'd like to start us off with is just, this evolving question that's been answered and asked time and time again over a very long time. And that's this question of, where do indigenous nations or tribes fit into the United States federal union, if they fit at all, right? And so if you want to go back immediately after the United States Revolution and maybe a few decades before that, there certainly was a point where European powers, which included both the British, Spain, France, and the early United States, there certainly was a time where those powers saw tribes, particularly the powerful tribes, as entities that they needed to ally themselves with, whether that's military alliances or entities with which they got permission to cross lands that the tribes occupied and controlled. And so at that point, that is when treaty making started, right? And treaties were the way that tribes in the early days in the East and these European powers went about memorializing their diplomacy. Later on, that power dynamic shifted quite a bit, but the treaties still remained to be the legal vehicle or the legal documents that wrote down what agreements between sovereigns were. And over time, those tended to be more and more one-sided, where the United States had a power imbalance. But if you get into the area that I teach and write in, federal Indian law, that discipline kind of comes together in the 1830s when the first cases that involved Indian law questions started going before the United States Supreme Court. And that is happening and coinciding with the Indian removal process, where by that time the United States is trying everything that's within their power to get tribes to agree to relocate to other areas because their land and their natural resources were so much in demand by settlers and by the states and by the United States itself. So those early Indian law cases kind of set forth three principles. Number one is that tribes are their own sovereigns, and that tribes' powers and tribes' laws flow from inherent tribal power. And so it's not part of the United States in that sense, even if there are United States boundaries drawn around the tribes don't get their powers by delegation of another source. Those powers that the tribes have are inherent powers. The second of those core principles relates to how we define the federal government, right? And in the United States, that federal power is particularly centered in Congress, is that if there is a United States entity that has control over Indian affairs, it's the United States and the federal government, but not the states. And then finally, what do we do with the position of the states in this discussion? And that is that federal Indian law tells us there's no such thing as inherent state sovereignty over a tribe. It has to get its power from the federal government, giving that power over to the states, or otherwise there's this tension and conflict between tribal power versus state power. So if you think about those three, core principles, and you fast forward a couple of hundred years and know that those are still part of the legal dynamic, now it takes us to the Mcgirt case. And the Mcgirt case came about as a criminal law habeas challenge, which means after someone is convicted in one court, they have the ability to challenge that conviction. And in two cases that went up from inside the Muskogee Creek Nation to the United States Supreme Court was the Murphy case and the Mcgirt case. And both of those cases were criminal defendants bringing post-conviction claims to have those convictions set aside. And in both of those cases, the argument was the defendant is an Indian person, and they are being charged for a crime that took place inside the Muskogee Creek Nation's reservation boundaries, but the entity that prosecuted them was the state. So in both of those cases, the argument is the state of Oklahoma was never given the authority or the power to prosecute crimes that involved Indians inside an Indian reservation, right? And for those of us who grew up in Oklahoma or have spent time now here on this college campus, you all will know that Oklahoma had long since taken the position for over 100 years that once the state of Oklahoma came into being, Oklahoma presumed that it had power everywhere within its state over everyone, Indian and non-Indian alike. And the argument of the state of Oklahoma in this case was that if those reservation boundaries were reservations when they were created, they certainly ceased to exist at some point over time, right? And the logical points of time would be during the allotment process, when land inside of the reservation boundary was divided up and conveyed from a principal chief to a tribal citizen, or at the time that Oklahoma came into the federal union as a state. The United States Supreme Court heard the challenge, and Mcgirt was the one that went before the full United States Supreme Court. And the court ruled that, yes, the Muskogee Creek Nation boundaries are an Indian reservation that were reservation at the time it was created, and it has maintained its reservation status all the way up until the present. And so if there was to be a sovereign that would prosecute the defendant in these cases, it would be the federal government under a federal Major Crimes Act, and or it would be a tribe that could prosecute under their inherent authority, and in some instances, possibly both the federal government and the tribe. But there was no provision for a state to have been granted that authority by the federal government unless it was expressly given that authority by the erasure or disestablishment of the Creek Nation reservation. And the court said that never happened, right? And that we can't imply or infer that Congress meant for a reservation boundary to go away. You look at the treaties and you look at the law, and if you can't find something that crystal clear takes those reservation boundaries away, then they must survive to the present. And so that's what happened in the Mcgirt decision. And I'll defer to my panelists with the other questions, and then I'll chime back in. Thank you.
Thank you, Dean Lees. That was amazing. It was very succinct and very informative. And I'm very glad that you took it all the way back to the Marshall Trilogy, and even before that, with the process of treaties and the development of two sovereigns coming to terms. So yeah, I'd like to turn over to Chief Wind to kind of address the changes that have been going on within the Muskogee Nation as a result of the Mcgirt and where we are right now today.
Thank you, Dr. Mosier, and good afternoon, everybody. So, August of 2017, myself and several of other light horse officers were sitting in a federal law update class in Tulsa, Oklahoma. Just so happens that we were on day 2, and our instructor was actually one of the authors of the handbook that the BIA uses for Native law. He walks into the classroom, has a smile on his face, proceeds to tell us about the headline in the Tulsa World, and it was discussing the Murphy case, where it had come out of the 10th Circuit, and obviously was getting ready to be appealed and sent up to the Supreme Court. His response was, the right call, the wrong timing. And little did I realize what exactly he meant. So from 2017 to July 9th of 2020, this department began doing what we could to prepare for what we would hope was inevitable. We waited for the Murphy case. Obviously, that was a draw. And then Mcgirt came up, and we thought, okay, we got a little extra time to start preparing. And so we actually went to the Navajo reservation, visited their police department to see how they were running their operation. Obviously, they cover parts of New Mexico, Arizona, and Utah. And with a reservation that size, we thought that would be pretty comparable to what we were possibly looking forward to. So July 9th, 9:05, I'm at River Spirit Casino for a meeting with Chief, Second Chief, and many others. And we get the notification that the Supreme Court had handed down their decision, and the Muskogee Creek Nation reservation was back. So within those years, as we were looking forward and reaching out to our federal partners, our state partners, and our tribal partners as far as law enforcement, we had started doing cross-deputization agreements. Now, a cross-deputization agreement is basically an MOU or an MOA that says our department's going to work with your department. We also at the same time worked on the cross-commissioning agreements, which would allow the outside department to carry our commission cards, authorizing them to act as light horse police officers. And prior to Mcgirt, that decision, we had about 32. Once Mcgirt hit, we actually had outside agencies reaching out to us, state and federal. And of course, everything just took off from there. One of the things that occurred immediately was our call volume. The call volume for our department has quadrupled over the past 4 months, where we may have only been getting 40 or 50 calls for service and maybe issuing maybe 20 or 30 cases. As of last month, like I said, we're up into hundreds of cases being issued, traffic tickets going up, just all across the board. Going back to the cross-deputization agreements and working with our federal and state partners, we've always had a good working relationship with our federal partners, the FBI, ATF, Secret Service. And so having already had those in place, that's given us an advantage over dealing with the federal crimes, those crimes that fall under the Major Crimes Act. And so we have a cross-deputization agreements with those entities, which is a huge asset for us, because part of the cross-deputization agreement, it allows those outside agencies to act as an agent for Lighthorse, which, understand, prior to Mcgirt, we had 30 some odd officers to cover 2,811 square miles, which, as you well know, we had the checkerboard effect here in Oklahoma and here within the reservation. So we really didn't have to have a very large police force. However, with taking over being the main law enforcement entity now within the reservation, we're obviously having to add officers. And so part of the cross-deputization agreements was helping to enlarge our department. One of the first steps I took as the chief of police, or the acting chief of police, was I approached our chief, second chief, and the council, and basically just, this is what we need as far as law enforcement. This is what we need as far as clerks, dispatchers, and so forth. So we were very fortunate that our council acted as quickly as they did, and we were able to get 39 additional positions within our department, which basically doubled our department. So as we are moving forward through these past months, we are coming across a lot of different situations that we hadn't really been able to look at. One thing to realize is, prior to this, there hasn't ever been, as far as I know, as far as we know, an event like this where all of a sudden you have a reservation return, if you will. And so there's not a guidebook, there's not a plan in place, or anything to help really prepare you. So unfortunately, we've had to do this as it comes. And I think as a nation and as a department, I think we've been pretty successful. Like I said, one of the first things that the tribe did was allow us to hire more officers. We've reached out to our stateside partners. We now have almost 60 cross-deputization agreements, which when you are the reservation law enforcement, obviously you're responsible for every Native American man, woman, boy, girl, which includes schools, such as your campus, Tulsa Public Schools. So one of the things that we hadn't considered was we're going to have to cross-deputize and cross-commission with even these school districts, which we have reached out, and we've done that. We are cross-commissioned with TCC's police department, and we are working with the Oklahoma University there in Tulsa, as well as OSU, NSU. So we continue to progress in reaching out to our partners. Part of that reaching out is also helping to educate them. Obviously, there's a lot of questions. There's how do we handle something such as traffic codes? So what we've done as a tribe and as a commission, which I'm sure John DeVoe will bring up later, we've been able to update and make more contemporary some of our laws. For instance, we just updated our traffic law. Why is that important? prior to Mcgirt, again, because of the checkerboard pattern and just our responsibility on restricted and trust property, we really didn't have to have a very robust traffic code. Now that we have the highways and the byways running through the reservation, we have that responsibility now. So the tribal council approved a new traffic code written by our attorney general and approved last Friday by our principal chief, David Hill. One of the other things that usually comes up in conversations with the outside agencies is medical marijuana. A document was drawn up by our AG and ran through the tribal court who approved it. And again, that was all signed by Chief Hill. So one of the many things that are going on here is we just continue to grow, continue to look at every facet of law enforcement and how it affects the other tribes within the Creek Nation, such as the increase in tickets. How does that affect our AG's office? How does that affect our tribal court? Domestic violence, which is obviously a huge topic for us here at Creek Nation. How do we make sure that no one falls through the cracks? How do we make sure that is properly gets to the proper people in a timely manner? So one of the big benefits is that it seems all of our departments are starting to talk a lot more. We're starting to work on that workflow between departments to get a better understanding, again, for the benefit and service of our people. So where we're at right now is we're continuing to learn and to grow within our department. If anyone's out there interested in law enforcement, hey, guess what? We're hiring. So please feel free to reach out to me. Thank you, Dr. Mosier.
Thank you, Chief Wynn. You are the busiest man in Oklahoma right now.
Yes, sir.
Jurisdiction has increased to 11 counties, and thank you. It sounds like you guys are taking some amazing steps to deal with this new situation. So we're getting some questions in, but before we turn over to questions, I want to invite Ambassador Chowdhury to kind of give us an idea of things as they are going forward. What does this decision mean? Some other issues have been raised as far as taxes and civil law. What about other nations and their route to follow with the Muskogee? So, Ambassador, if you're ready.
Absolutely, and I too would like to thank you, Dr. Moser and Dr. Todd, as well as the entire faculty at TCC. I've never been able to join a program for TCC. I've always respected the college. You're kind of in our circle, and just it's a deep honor. But it's also a deep honor to join Chief Wynn and Dean Leeds. Deep respect for them. They both serve, in addition to their day jobs, they both serve on Creek Nation's Reservation Protection Commission, and that commission was created by Principal Chief Hill in direct response to the immediate transition needs arising from this historic win. And that commission has gone about its important work in steadfast commitment to this important goal. And it's comprised of, I think, over 40 Creek citizens or folks within the Creek government to address every aspect of governance that Mcgirt touches upon, but also address external outreach to sister sovereign agencies and businesses to figure out ways to work together to really embrace the opportunities that come from Mcgirt. And that's what I'd like to talk about today. Chief Wynn talked about operations kind of on the ground, the day-to-day work of keeping people safe, implementing Mcgirt in a responsible manner. Dean Leeds talked about the historical backdrop leading to Mcgirt. I guess my talk is going to be about what's in the middle of that. And for that, I'd like to talk about how false narratives often drive, unfortunately, policy in Indian law, and how they've certainly driven policy that has directly impacted Creek Nation. since the formation of the United States, and they're driving, well, they're attempting to drive policy now, and that's what I want to talk about. So, as Dean Leeds mentioned, in the early days of the American Republic, the United States, and before the U.S., the colonies, really had to work with tribal nations to even come to existence in the first place. The alliances with the key alliances with tribal nations truly did help the Republic win the Revolution. And in the early days after the formation of the Republic, treaty making with tribal nations was critical to provide legitimacy to the United States on the world stage. The US Constitution, as we know it, was passed in 1789. Creek Nation entered into the Treaty of New York in 1790. It was actually the first tribal nations treaty with the United States after the formation of the Constitution. And that treaty itself was important because it set out the boundaries of the southeastern part of the United States. And it wasn't a perfect treaty for Creek Nation by any means. Lots of land was ceded, as is often the case in many of these treaties, but at least it set forth the boundaries of Creek Nation at that time. Since then, between 1790 and 1866, the year of the treaty that's relevant in Mcgirt, there were several other treaties, all of which ceded huge portions of Creek Nation's lands in return for certain promises from the United States. And finally, in 1866, we're all familiar with the boundaries that resulted after another cession of land that were established forevermore to be Creek Nation's reservation boundaries. It was that treaty and the promises made in that treaty that Justice Gorsuch was referring to in his first line when he said, "At the far end of the Trail of Tears, light a promise." Well, each of those treaties came in response to different policy pressures in the United States, and most of the relevant acts that impacted Creek Nation came in response to various public pressures driving towards a call for more Indian land and more Indian resources. Let me give a little backdrop just to kind of frame this story about false narratives. I was very fortunate to have had the opportunity to go to law school, and a lot of folks, but actually probably the vast majority of folks that go to law school in their first year of law school, probably in their first week of law school, are in a property class and have to learn about the case Johnson versus McIntosh. Now that case is an Indian law case, but it's also a foundational property case that's taught for all property classes because it established the workaround the Supreme Court entered into to get around Aboriginal ownership or indigenous ownership of our lands. That case was the case that found a pathway to justify the federal government's ownership of the lands. And that case itself was built on a false narrative. Let me read a couple lines from that case. To paraphrase, Justice Marshall explained, tribal nations could not be left, quote, in possession of their country, end quote, because Indians were, quote, fierce savages whose occupation was war and whose subsistence was drawn chiefly from the forest, end quote. As a result, quote, to leave us in possession of our country was to leave the country as a wilderness. Okay, that's important. Creeks, like Cherokees, like many tribes all over the country, have a long history of being very sophisticated cultivationists. And we cultivated agriculture. Corn woman is a foundational story in our nation. We're very sophisticated people. In fact, we developed this staple food that feeds the entire world. Yet, in order to explain why it was okay to remove us from our land, or okay to say that we didn't have true ownership interests in our land, the Supreme Court had to create this story that we were just basically renting the land, or we didn't really own the land. We just were like wild animals running on it. That was the backdrop for American property law in the United States. You fast forward to the late 1800s and the early 1900s, and the allotment policies, I won't go through all the quotes like that, but the allotment policies were based on similar false narratives. And the false narratives that existed then was that in order to survive, Indian people had to assimilate. They had to get with the program and learn how to be good property owners and good farmers. Again, the fact that anybody was claiming that Creek Nation or Muskogee people or Cherokee people or Choctaw didn't know how to farm was ludicrous, and people knew it at the time. But these were stories that had to be told to justify the chopping up of lands and the opening up of lands through allotment that Congress wanted to push. So that was the storytelling then. In the lead up to Mcgirt, we heard very similar storytelling. And that's why I'm so thankful to be on this panel with Chief Wynn. Chief Wynn, I'm sorry, maybe you should be a justice given all the hats you're wearing right now. But yeah, I'm so honored to be here because his work was not recognized in the briefs of the state of Oklahoma, as well as various special interests who filed supporting briefs from like the oil and gas perspective. That they tried to develop this sky is falling narrative that chaos would run rampant in eastern Oklahoma if the Supreme Court upheld its precedent. They tried to tell the story that our court system, our law enforcement system weren't capable of performing the tasks necessary to run a government, and they tried to build this false narrative. We all knew that wasn't true. As Chief Wind mentioned, we had dozens and dozens of pre-existing cross commissions and intergovernmental agreements already in place. And we had already had a long history of working with our county, local, state, federal partners to ensure public safety was protected. But we also understand the importance of building those false narratives to push bad policy. We understood that there's a very real likelihood that these false narratives, the goal of them isn't necessarily just to ensure public safety. It very likely is to ensure that the perceived status quo, and I use the word perceived because the status quo was never that the state of Oklahoma had this authority. In fact, the Supreme Court patently found that the state's exercise of jurisdiction over crimes committed by Native Americans was illegally being exercised. But their intent was that the perceived status quo could be put back into play, could be preserved. Those were the narratives that led up to the case. Justice Gorsuch and the Supreme Court didn't buy it. Instead, they listened to the stories that the Creek Nation, as well as many other groups who filed amicus brief, put forward to carefully lay out that history that Dean Leeds mentioned about the foundations of sovereignty, about how our reservation was never disestablished, and how our reservation has always been here. The court got it right in a very well-reasoned argument, opinion. The court blew apart all the state's arguments and found that our reservation remains in full force and effect. But in the immediate aftermath of the case, those storytellers, those false storytellers, were back. We're back at it. The ink wasn't even dry before the folks who claimed there would be chaos started to say we need immediate legislation to address the jurisdictional gaps created by Mcgirt. Anybody who's practiced Indian law as long as Dean Leeds or I have knows how laws work on reservations. There aren't jurisdictional gaps. Between the federal government, the state government, and the tribe, somebody has jurisdiction over everything. And it all comes down to collaboration. And Congress doesn't need to act for folks to collaborate or cooperate. But the intent was to get congressional legislation to overturn all or some of Mcgirt. So these narratives came about again. And again, we recognize that these narratives aren't just about public safety. It's about trying to put things back into this perceived status quo box. And that's where we are today. In the last 2.5 weeks or so, we've had a pretty powerful organization, respected in some quarters, not all, call for the disestablishment, the outright disestablishment of tribal nations. I'll mention the name of it, even though not everybody really puts a lot of stock into their positions, but it's the Oklahoma Council on Public Affairs. The state governor, Governor Stitt, had a commission of his own, none of which involved any tribal input, but that commission has come out and said that disestablishment of tribal nations should be considered. And then we have if that's the bad cop scenario, you have the good cop scenario, or the lesser bad cop scenario, of a proposal from the Attorney General of the state saying, well, let's go to Congress to try and at least allow for compacts to be entered into. And for reasons I could get into further, there's already a law on the books that allows for compacting. It's an unnecessary and, frankly, from Creek Nation's perspective, dangerous proposal. But we're used to this. We've been students of history. We know that false narratives push bad policy. It didn't work this time. It didn't work in the court case of Mcgirt, and it's not going to work in the aftermath. But we're being vigilant, and it's through the hard work of the commission, the day-to-day work of our courts, and the day-to-day work of our light horse that we'll be able to shed light on these false narratives. There may be transitional issues that come up from time to time, but we're convinced that through this day-to-day work and in the spirit of cooperation with our partners and intergovernmental agreements, we will show the true source of these false narratives, and we'll show that they're completely not grounded in anything close to reality. And so happy to answer more questions, but just honored to be here. Moto.
Thank you, Ambassador. And I really appreciate what you had to say. And I love the thread that you were able to draw all the way back from the early Marshall decisions, this false narrative that continues as the United States tries to grasp with tribal sovereignty. And I wanted to point out some of the things that you were talking about that are still going on as we speak. And some of the things that I wanted to get accomplished today, I was talking earlier with Dean Leeds about this, is that the position that's coming from the state, it seems like that this is a new thing, that the Supreme Court just granted this surprise status to the Muskogee Nation, but it's a reaffirmation of what has been going on, or what should have been there all along. And I think Gorsuch did a great job with his opinion. And he has several quotes. One of them that was really good that I liked: unlawful acts performed long enough with sufficient vigor are never enough to amend the law. So one of the arguments that the state was making is that this has been going on for so long, we should just be allowed to perpetuate this system. And I appreciate the fact that Gorsuch was able to step on that. But the false narrative that's going on, I think, today, that I love how the ambassador used the term opportunity. Because what comes from state officials, the term that they're throwing out is uncertainty. And that's what they keep on harping on, that this is just going to create chaos, that the nations aren't able to handle this. And it's this lie that they're perpetuating to spread fear. But the reality is not that. And I would like, would anyone just take a moment to tell our panel what happened when Mcgirt was retried in a federal court and the decision came down last week?
Dean Leeds, or?
Oh, it doesn't matter, Doug. Ambassador, go ahead.
Okay. Well, was convicted, and that's the point. So immediately, the United States, the U.S. Attorney's Office brought charges against both Murphy and Mcgirt, and that proves an excellent point. And this is a point we make quite often at Creek Nation. First of all, the category of cases we're talking about are crimes committed by Native Americans. Now, that's certainly significant, as the hard work that Chief Wind does will testify to. That does result in a greater need for capacity within tribal courts and tribal law enforcement offices. But let me be clear, the number of cases hasn't increased. There's still the same number of people committing the same types of bad acts that always occurred. What's changed is that now we have an opportunity to show that through local decision making and local problem solving, the tribal nations have a role to protect the public like they've never been allowed to have before. So in a very real sense, legally, people were safer the day after Mcgirt than they were before, because you have local governments on the ground taking care of public safety. But practically, they're safer too. As Chief Wind mentioned, one of the first acts of the National Council of our tribe was to approve funding, and it's much needed funding for Creek Nation. We're not a rich tribe like by any means, but to approve funding up to this point, I think it's well over $2 million to add to the amount of light horse folks on the ground, add to our court system, add to our social worker programs, do all these things necessary. This is adding more muscle to the ground to address public safety in a situation that there aren't any more new crimes. This doesn't take away law enforcement that existed before. So we have more law enforcement than ever before going after the same bad guys. And moreover than that, where there was one jurisdiction, the state of Oklahoma, that prosecuted these crimes committed by Native Americans before, now there are two jurisdictions. Where we had one jurisdiction, the state of Oklahoma, who frankly did not always have the strongest record of prosecuting violent actions, especially against Native American women on tribal lands in Oklahoma. Now we have two. And not only do we have two jurisdictions, we have two superpowers at hand. We have the United States and one of the foundational tribal nations in the country, Muskogee Creek Nation, who, as I said before, were there from the first days of the Republic, teaming up to go after bad guys. And so this is a good day for the citizens of Oklahoma and a bad day for bad guys.
Thank you, Ambassador. Dean Leeds, maybe you can help us out on another question. Why is the state so hesitant to see this happening? Why is the reservation from the state? Why are they? Is it the fear of loss of power? Or do they not believe that tribal nations are capable? Do you have any understanding of what their hesitancy is?
Change is hard, right? And if you are a sovereign that has spent the last 113 years operating in one way, and then you're told that that can't happen in that same manner anymore, you're not going to be happy about it, right? And so, number one, I think it's a human nature question of just the change. Number two, I think that it's, power dynamics, right? It's the tribes that, whether it's fair or not, a lot of Oklahomans look at tribes and they think that that is a lesser sovereign and not the same as the state or the federal government. And so, part of it is growing up with those false narratives, but part of it, it's just, I think, the innocent unknown. When people hear tribal cops or tribal judges or things like that, and they don't have personal experiences with that, the other is always less than or less qualified or whatnot in people's minds. And so I think that that's part of it, but I would just invite anyone who still subscribes to that sort of mentality to come spend a day down in the court at Muskogee Creek Nation, or to spend a day with Light Horse, or with the prosecuting attorneys or the public defenders who protect people's rights in tribal court. And I think that in Oklahoma, probably more than anywhere else in the United States, you're going to find two systems where the people all went to law school together and they graduated from the same schools and they live in the same neighborhoods and their kids go to the same schools. And so I think when people unpack what's really going on and truly see what happens 6 months, a year after Mcgirt, every day, I think the attentions are going to continue to decline. I like to remind everybody that this is not the first time that the federal courts have had to step in and tell the state of Oklahoma that they're overstepping their boundaries. We have modern day tribal courts throughout Oklahoma that got their genesis in the 1980s, late 1970s, 1980s. And the reason for that is that Oklahoma was exercising jurisdiction everywhere inside of Indian country, including on trust and tribal restricted fee properties. And when the challenges to that tribal land came up in the 1980s, we heard that same sky is falling, mentality. Oh my gosh, what's going to happen when there's a 911 call or when a sheriff needs to respond? And so after those decisions that told Oklahoma that they were overstepping their boundaries, that's when we first got cross-deputization agreements between tribal, federal, and state law enforcement officers. And it wasn't an accident that the day before Mcgirt, as Chief Wind mentioned, that there's 30 cross-deputization agreements pre-existing that moment, right? So it wasn't as if tribes needed to reinvent the wheel. They already had police officers. They already had their tribal court systems. And I just like to remind everybody that we're at tribal sovereignty 2.0 after we already experienced this. Now, we experienced it on a smaller scale in the 1980s, but it's not a new thing. It's just amplified a little bit. But one thing I thought that I would share, Chief Wind mentioned the increase in phone calls and service activity with the light horse. I too can share some stats from the trial court in the Muskogee Creek Nation. And if you look at felony cases, in the time frame from January 1, 2020 until the day that Mcgirt was decided, there were only 16 felony cases in tribal court. From the day that Mcgirt was decided until the end of October, it was 321 more, okay? So there definitely is an increase, but it's 320 in about a 5-month window. It's not 3,000 or 30,000, right? And so, like the light horse, the court is, hearing more cases, and it's hard. And the people who are the staff, particularly in the court system, are working harder than ever, and we'll need more clerks and bailiffs and, everything that you can imagine in a court system. But it's not as if we're starting at ground zero. We're starting well, into decades of having these institutions and these laws in place. And so when I hear, people talk, particularly in the media or on social media, about what a bombshell case or what a significant thing this is, I don't want to downplay the significance, because it is a big deal, both practically and legally, but it's not insurmountable by any stretch.
Thank you, Dean Leeds. We had a question for Chief Wind. They were talking about the cross-deputization. When you enter one of these agreements with, let's say, the Tulsa Community College Police, is there sort of cultural training that is required as part of that contract?
It's not required. However, we're trying to get our training staff out to as many locations as we can. Not so much, well, partially for the culture, but just to kind of give them an understanding of what exactly tribal law enforcement is. Just like Dr. Leeds and John Deva just mentioned, we've always been here. We've been here. We've been a police department since 2003. We had security since 1979. We've always been here. Most people, like Dr. Leeds said, just didn't pay us mind. That's one of the things I was wanting to kind of reply to was, one of the most surprising things, when I started going out, my deputy chief, we would go out to all these different agencies to discuss the cross-deputization agreement and offer that training, offer that teaching of what are the differences. When one of the first questions I would ask is, what do you know about Creek Nation Police Department? What do you know about Light Horse? And I have to say I was stunned by the amount of people, the amount of officers and chiefs of police that would say, I don't know. They didn't realize that everything that we have you're going to find in the bigger department as far as emergency response teams. We have our own dive team. We have our own hostage negotiator. We have we've spun up a cyber crimes. We work with the FBI on a daily basis. We work with the Secret Service. We work, and yet no one ever paid enough attention to us to realize what we bring to the table up until now.
Thank you, Chief Wynn. Very informative. Ambassador, do you think that other tribes will follow suit, other tribal nations will follow suit in trying to get their reservation status solidified?
Well, this is why this case is so important for Indian country. Some tribes have already followed suit. So I know that this case has been framed as a 5 tribes case, and clearly it impacts the 5 tribes. The 5 tribes all have similar treaties, not identical, but similar treaties from around the same time. Not all their language is the same, but folks are pretty confident that as the courts apply the analysis that Justice Gorsuch applied, they'll come to a similar conclusion that their reservations weren't disestablished. But it's certainly not just a 5 tribes case. Just in the interest of time, I won't go into a lot of details, but bottom line, the court's holding was based on a long-standing precedent that unless the United States, through an official act of Congress, shows its face to the world and explicitly diminishes or disestablishes a reservation, that reservation exists. Going into the case, we thought that there was a chance that the analysis would hinge on certain minutiae within our treaty. But in fact, Gorsuch's analysis didn't just, I mean, it looked at all of the history of state actions, congressional actions as a whole, and simply asked the question, did Congress ever affirmatively, explicitly disestablish or diminish Creek Nation's reservation? And finding that hadn't, Justice Gorsuch said, will hold the United States to its word. That analysis, in theory, applies not just to treaty tribes, not just to the 5 tribes treaty rights, but to all treaty tribes, and theoretically applies to any reservation that has a statutorily created reservation or an executive order reservation. So what I mean by that is reservations were created different ways throughout the United States. A lot of the reservations out west are executive order reservations. But this idea that only if Congress shows its face to the world can you find disestablishment applies to anybody who whose lands haven't been disestablished. Now that will still be a small number of tribes, but we've seen Mcgirt referenced by the 7th Circuit in an important case dealing with Oneida of Wisconsin. We've seen within the 5 tribes, different cases bubbling up through the state court systems where, as we knew they would, where Mcgirt's being referenced. So this was a win for all tribes in Indian country. But the point we make was this was a win for all Americans. Okay, and this is very important. The sky is falling narrative seeks to scare and use that fear to drive bad policy instead of pointing out the opportunities that exist. And what are those opportunities? We've seen that tribal economic development benefits non-natives just as much as it benefits natives. So when tribes engage in economic development to build revenue for critical programs and services, there is a benefit to non-tribal members as well. What are those benefits? Their jobs, their creation of resources at home. The revenues brought in by tribes are governmental revenue. They're not profits. Profits go to shareholders who often live out of state and sometimes out of the country. Any business that's done in Indian country has a recycling effect back home. But on top of that, it's got a multiplier effect because you're funding other downstream businesses who are vendors to those businesses, who are employees, and so on and so forth. Then infrastructure. the utilities, the sewage, the water, the electrical infrastructure that tribal nations build service everybody within a reservation. They help everybody. We all drive on the same roads. And then finally, healthcare. Creek Nation operates two of the best hospitals in the area, as well as numerous clinics. And we serve citizens and non-citizens alike, non-natives. Finally, business incentives. Folks who have worked with tribal nations, and we've seen this as folks who have practiced in Indian law throughout Indian country know that you can work together. It's not just all about tax rolls. You can work together to provide incentives to bring business onto the reservation that benefits everybody. So the sky's falling narrative is intended to shove things back to this purported status quo. It's counter to the interest of the Oklahoma public, counter to the interest of Tulsa, because we should be focusing on the opportunities in front of us, whether it's business incentives, infrastructure, first responders, so on and so forth. This is a huge win for the American public. So when I say other tribes outside of Oklahoma can benefit, the first reaction people should be, great. This is an opportunity for more resources to come into our lands and to have additional governmental assistance on public safety issues. Instead, folks want to scare people with that. But we're here to educate, and that's why the panels such as this are so important.
Thank you, Ambassador. And what you have made is an excellent counterpoint to the Oklahoma Commission of lights are going out of my office. My goodness. To the Oklahoma Commission on Cooperative Sovereignty, they came out and said that one of the biggest hiccups about this was that out-of-state businesses are not going to want to work in Oklahoma because of the issue of uncertainty, that this would drive them away. But you have demonstrated the complete opposite, and I thank you for that.
Yeah, and just to build on that, I know Dean Leeds has worked all over the country. There are commercial corridors. I've worked in Arizona, and there are whole commercial areas where the tribes have set aside areas of opportunity to work with non-Indian businesses, to bring businesses in. Sometimes folks live in those areas, and in addition to that, there already are plenty of places, and I think of Tacoma, Washington, or Green Bay, Wisconsin, where you have major cities within reservation boundaries already. The sky doesn't fall. You work together, you build commercial corridors, and everybody benefits. So thank you for that opportunity to dispel that myth.
Thank you. We have another question here. How could the President Mcgirt affect Alaskan Native corporations, if at all, such as the ANSCA?
Dean Leeds, do you want?
Yeah, I'll take that one. I don't think that there's going to be much implication or overlap with issues in Alaska. This gives us very clear instruction about how a court is going to determine the existence and continuation of reservation boundaries. And so, although it's broadly applicable across Indian country, it really is a case about whether boundaries have been erased or not. And I just don't see that there's a direct application to that issue out of Mcgirt.
Okay, thank you. And Hawaiian Islanders as well, or?
Same thing under United States law, that the classification of federally recognized tribes doesn't apply to individuals in Hawaii who are indigenous to Hawaii in the same manner. So, it may signal a shift in a court, but now that court has already changed makeup again. And so, there's broad ramifications, I think, in the lower 48 with reservation boundaries, but unless there's a continuation of a trend in the court that is more pro-tribal than what we've seen over the last 3 decades, but we have seen in the last 3 years, unless that trend continues with the changing makeup of the court, I really think that we're talking apples and oranges there.
Thank you, Dean Leeds.
Mm-hmm.
We have another question. You might be able to answer this one too, about Senator Inhofe's 2005 Safety Act, where the EPA grants Oklahoma's Regulatory Commission control over environmental issues in Indian country. This goes to another question that I kind of want to get on, the extension of McGirt beyond the Major Crimes Act. You mentioned the Major Crimes Act when you were talking initially. Could you tell us just a little bit more? And then does the McGirt decision have implications in civil, tax, maybe family and adoption and that sort of thing as well?
Sure. So the Major Crimes Act was the federal law at issue in McGirt. So the court, although the decision may later be used and applied in other cases, it really is a narrowly tailored focus on the felony type cases that would happen in Indian country pursuant to that piece of federal legislation. But to be very clear, when the court made a determination that the Muskogee Creek Nation's boundaries survive and are still in existence today, then it shifts us into a conversation about what are the powers of tribes, states, and the federal governments inside of an Indian reservation, right? And so it definitely will have ramifications to some extent in civil cases, probably taxation. And so, people who have studied history and law have for a very long time been told that the Oklahoma tribes, particularly the 5 tribes in eastern Oklahoma, that their situation is different and that the rules that apply to every other Indian reservation across the United States don't apply. Well, now we know that that's just not true, right? And that that's not how the Supreme Court views it. And so I don't think that there's uncertainty. I think that you can look at many, many, many tribes and the powers that they have and that the states that they are, find themselves now geographically within. So there's a roadmap about taxation. There's a roadmap about civil jurisdiction, regulatory jurisdiction. There's a roadmap about all of those types of things. What does keep Oklahoma tribes and the 5 tribes in particular a little bit different is that there has been, over the course of the last 113 years, some very specific federal statutes that were passed that were harmful to the 5 tribes. So for instance, if you're going to have a probate case in Oklahoma and you're in Indian country, even on trust or restricted property, federal law says that that probate case goes to Oklahoma County Court, right? And that's still the case long after McGirt until there's some change in the law. The environmental piece is another part of that, right? It shows how some congressional leaders can be successful in getting negative pieces attached to otherwise irrelevant bills, right? And so that that rider that was attached in 2005, which targeted the right of tribes in Oklahoma to govern their water and their air quality, and said that unlike the rest of the tribes across the country that can get, state treatment as a state to do this, if the tribes in Oklahoma are going to get that, they only get it when Oklahoma agrees to it, right? And so that law has been in existence for quite some time, and there hasn't been any activity on it until after McGirt. And so it kind of looked like a revenge piece, right? That it would be acted on now, even though that authority was there, previously. But I think that, all of these things punctuate how, although McGirt was this excellent win for Muskogee Creek Nation first, and then other tribes that will follow, the bottom line in McGirt is that under current federal Indian law, if Congress decides and has the political power to enact a statute that's harmful to tribes, they're recognized as still having that authority to do those kinds of things. And sometimes they can exercise that power for good things, like the Indian Child Welfare Act to protect our kids. But sometimes, like the example with the environmental statute, they can exercise that power for things that are very detrimental to tribes. And the courts will back them up in doing that if what they're doing is very expressly spelled out. And I think that that's something that we all have to remember, because we're still operating in a system where Congress, if politics aligns itself, is very powerful and can be hurtful to indigenous peoples.
And if I may add to that, I couldn't agree more with everything Dean Leeds said. To my knowledge, many tribes in Oklahoma are looking at, what options or tools are available to to possibly challenge this, this grant of authority by the state, whether those are legal or administrative or what have you, because bottom line, the process that was created carves out Oklahoma tribes as a different type and a different status than tribes throughout the whole country. And that's, there wasn't any justification for it. And in DC, we call it airdropping. They airdropped that legislation into this massive transportation bill that frankly had nothing to do with the subject matter of this act. And, you know, being students of history, we of course don't want that to happen with Mcgirt. So we're watching very carefully that that doesn't happen. But in terms of this EPA action, folks are looking at options right now because, you know, shoving this act down the throats of tribes doesn't do much to build cooperation and intergovernmental collaboration. And we see that that's the path forward. I mean, Creek Nation, you know, we're Oklahomans too. We're citizens of Oklahoma. We have an interest in all of our sovereigns working together, and congressionally imposed limitations on that ability are just unfortunate.
Thank you. And I also I want to make sure that everyone that's watching knows when we're referring to Congress, or we're referring to the United States Congress, the state of Oklahoma does not have any power to change the boundaries or to do anything with the status of a reservation within its borders. That's been clear. Does anybody have any other questions? We've had some really good ones coming in. I think I've been able to address all of those that I see. Okay. Well, if we don't have any other questions coming in, can we maybe take just one second? I want to thank everybody here, especially our guests. We are very honored that you were here with us today to share your knowledge about this topic and to help clear some things up for us and to kind of help us plot our own course going forward. So thank you to Ambassador Chowdhury and excuse me, for Chief Wind and for Dean Leeds. Yes, thank you to all of you for your time and for sharing with us, for being with us here today. This is an incredibly important topic, and we are very, very, very thankful.
It's been truly an honor. Thank you so much.
Thank you.
Mado, I appreciate the opportunity to share what we've gone through, and if anyone has any questions, you're more than welcome to reach out to me. I'd be happy to answer anything that I can.
Thank you, Chief Wayne. We'll see what we can do about getting you some more deputies.
Light horsemen, no.
Light horsemen, yes, sir. Absolutely. Well, okay. Well, I'm going to go ahead and turn it back over to Dean Nate then.
Yes. You know what? This has been a fantastic discussion, and I know I was actually taking notes and everything, and you know, you think that you know something, right? And then you have to get with the experts to really kind of dive in deep on what's actually going on. And I think that we were able to truly do that, and we have some amazing people within the Muscogee Creek tribe who's able to really educate us on what's really going on, instead of us trying to make assumptions and think that we know. And so I would just like to once again thank our panelists for your experience and your insight on this topic. And then of course to you, Dr. Mosier, for moderating this and facilitating this discussion. You know, this is just the tip of the iceberg of really allowing us to be fully engaged with our indigenous people here in Oklahoma and the surrounding areas. And so with that, we do have an event next week on November 20th at 1 o'clock. We will have Joy Harjo here, who is our 23rd Poet Laureate for the United States, and we look forward to seeing everyone who's in this Zoom call today there next week on November 20th, and we thank you once again for spending just a little bit of time with us today. And I look forward to our future talks with everyone here on this panel. And I know that we will definitely continue to work together in the future. So thank you so much. So with that, we're going to sign off, and I will look forward to seeing everyone next week. So goodbye, y'all.
Go.
Onondaga.